Vado, bravissimi, grazie. Buongiorno a tutti, sono Nicola.
Good afternoon, everybody. I'm Nicola Di Lernia. It's a great pleasure to chair this pleasant and unusual debate and comparison between the ophthalmologic world, and I'd like to extend my greetings to Professor Avitabile, President CISO, and then we have a friend. We've been attending this conference for so many years. President Fragoli, Federotica President, and together with him, lawyer Stefanelli, an expert at health, with a long-standing experience also in the field of eye medicine. We have the representatives of the relevant categories, and over the past few years they communicated and they tried to identify points in common. And today we start from three objectives identified well by the speakers. We start from mutual complexity, because each category has got its own complexity, to get to similarities. That is to say, there are certain things that can be tackled together, and it's just like when two friends meet and they say, if you have this problem, more or less I have the same problem as well. To understand at the end if we can find some sort of integration, those steps that were not taken over the past few years to get to something better than in the past. I'd like to remind you, also those following us from home, this legal, in a way, studio will be recorded and streamed. Professor, you delivered, you have a presentation to speak about the various problems.
Si sente adesso?
Can you hear me now? Yes. We were the object, we were a target over the past few years, not eye doctors. However, we're not at the top level, but we're not the last. And medical complaint, and it cost 11 billion euros. Defensive medicine, it's crazy. And Minister Schillaci, together with Minister Nordio, are trying to find a solution to this. Why did I get passionate about medical liability? Now I'm just a storyteller all over Italy, but I was a surgeon of the retina. My first operation was when I was 28 years old, and but I received my first complaint for a patient operated successfully, retina detachment, and a long story of the patient who unfortunately was affected by phthisis, not because of my fault, but because of what happened after. The request was 500 million liras, and I didn't sleep at night, and I was in the States, and I didn't imagine that this lawsuit would last years. When we tried to defend ourselves, we told the judge, very few surgeons, very few of them operate, very few back then. Those that operated cataract, and very few retina detachment. And so I appointed a neurologist. Paolo, you're smiling, but you wouldn't be smiling if you were in my shoes. And today, all of this cannot happen. And Then they said I was right, and so that's it. And at long last, March 8, Jelly Bianco law. And when somebody says it was of no use, they don't tell you the truth. And you see, there's a considerable reduction in disputes with the Jelly law. And I played a role in all of this. It's a fact. The law is there, and before I wrote to an expert that the judge should have had specific experience. You see, Federico Gelli, it's not a photomontage. And former Article 10, you can see it just above. You see amendment of the rapporteur. Gelli made such changes because he was convinced about what I told him, and he added a specialist of the field that has specific knowledge. That this becomes Article 15. It's binding law today, and should have specific knowledge of the subject of the dispute. And then you have a circular letter and of a higher body, CSM, telling the judge what the judge should do, a specialist at the subject of the dispute, and also practice. Another positive element brought home with the Jelly law is that liability is on the structure. We are employees. It's not right. They should be liable personally. The hospital must be liable. It's not always so, but that's the spirit of the law. And when the hospital, however, when you are the operator with Article 13, they warn you. On the basis of all this, we prepared an insurance package. It's the top that you can have. We have chosen the best broker in the world, Marsh, and the best insurance company existing today in the world. Berkshire Hathaway, that has outperformed Allianz. I am through with professional liability, and there's a chapter on eye emergency. If you want to give them the floor, then we'll go back to it. And the eye emergency service has already started. We are the front office, in a way. And a client, a patient, comes to you with a red eye, with a problem. And if I tell the patient to book a visit, well, it can take 2 months. And if I send the patient to a public structure, it's not the optimum. But we have decided to set up an eye emergency unit managed by CISO. We'll see it after. This idea originated from the exchange between the two professors and Bologna. Not so much you as a president, but opticians expressed this type of need, that when problems are encountered, sending clients to an eye doctor was difficult, and perhaps you have the same problem. Then we see what happened. President Afragoli, are there similarities between what Professor Avitabile has spoken about and your world? What's the situation today?
In questi termini,
well, luckily, not in these terms. I think 500 million euros is a huge amount, but the world is changing, and we are all exposed to these issues and problems, and lawyers, of course, benefit from it. Well, as a category association, well, I do not want to do any marketing campaign, but we bought civil liability insurance many years ago. Of course, we do not need the same insured amounts as surgeons require, but there is definitely something new ahead of us, which is not necessarily nice, because, you know, in the past, the approach was completely different. The approach to damage or accidents in any form. And now, well, you know, customers and patients have a completely different approach. Well, in a nutshell, we are particularly exposed in the field of contactology, in specialist contactology. I mean, the use of contact lenses on special situations, in special situations such as, for example, keratoconus, transplantation, night orthokeratology, for example. These are all issues that require a lot of attention, because they may lead to legal complaint. But this is part of the game, you know. For surgeons, for example, it may well happen that sometimes a surgeon incur problems due to that in a completely different scale, but those well, practitioners in this field are exposed to a certain number of risks. And then there is a situation which is not completely new. However, this is a situation that is becoming worse and worse, and which is linked to the use of devices such as glasses. Well, glasses or spectacles are a low-risk device. These are not mitral valves, for example. However, there are people filing a complaint against the optician or against the manufacturer of glass components after accidents, and these legal complaints are becoming more and more frequent. Just to mention an example, a colleague of mine from northern Italy received a complaint together with the company manufacturing the lenses because a kid fell down in the kitchen. Well, he was particularly unlucky, but a kid falling down in the kitchen hit against the corner of the oven door that was open. Well, he was wearing spectacles, the lens got broken, and the splits caused severe corneal damage. Well, of course, we wish this kid all the best, but one of the hypotheses is a transplantation. Then, of course, a damage occurred and a claim for damages was filed. Well, I would wonder what would have happened if this kid hadn't worn spectacles. Well, he may have incurred much worse damage. But the issue is, as soon as I manufacture a pair of glasses for specific consumers, for example, kids, athletes, or people with dangerous jobs, well, apart from personal safety equipment, I'm not talking about welding glasses or chemical glasses. What kind of attention should I pay? Well, this is the risk analysis that maybe the lawyer can elaborate on. Lawyer Stefanelli, I have two quick questions. Well, first of all, I have the impression that there is a lot of pressure coming from the consumers' world. Nowadays. In the past, all these issues, well, I don't know, tended to be overlooked, or I don't know what happened. So my first question is whether there is this pressure. And then what about what you heard from both presidents? What do you think about these two worlds? I started working in 1991, and I've always been dealing with healthcare issues. Well, 30 years have passed, and across these 30 years, the world has dramatically changed, if you think about it. I will then go back to the field of optics and eye surgery. But if we think about the societal organization and the complexity of society, well, clearly, if we just think about the explosion of the digital technology, well, this has led both the Italian and the EU legislator to regulate and not only the possibility to claim for damages, but also to regulate prevention. And prevention works on the processes that occur and are carried out in healthcare. Well, in this respect, everything has changed, the society has changed. Now entrepreneurs have to focus more on prevention, and this happened in the healthcare sector as well. In healthcare, it is important to increase the number of prevention measures to take, and this requires a new process organization. And there are rules and regulations in place in order to avoid, as far as possible, the filing of claims for damages. The Jelly Law, the 2017 law that was mentioned earlier, transforms this prevention process into a sort of constitutional law, because the safety of care is a part of the law. And by safety of care, we do not only mean medical measures, because medical measures are functional and effective if the context around the practitioner allows him or her to do his or her best. Well, you know, if the system doesn't work, then doctors are prone to mistakes, that's clear. In our industry, we are very, there is a very close interrelationship between the provision of services and the provision of a pair of glasses. But, the provision of services occurs in different locations. If we think about other sectors, for example, the orthopedic surgeon and the manufacturing of a prosthesis or the adaptation of a prosthesis, this may happen in the operating theater as well. And so we have a very close connection between the provision of a service and the provision of a product. In our sector, there is not such a proximity or such a close interrelationship. However, we have a close involvement and a close proximity between surgeons and opticians. From the viewpoint of the consumer, this is just one single care process. Of course, we are on the other hand, on the other side of the table, and we perfectly know that these two jobs are completely separate with different problems and issues. However, from the viewpoint of the patients, both practitioners belong to the same process. Well, patients have much higher requirements than in the past, and this holds true for all societies in developed countries. Economic situations have improved in the past few years, and as a consequence, the level of expectations has increased. And so again, the patient perceives the provision of healthcare services as a single flow. Patients want to feel well, and so they resort to practitioners in order to improve. However, I do not want to be too lengthy. So in conclusion, if we consider this context from afar, and if we take the whole flow into account, we recognize that on the one hand, the Jelly Law has focused much more on the importance of care and organizational measures. On the other hand, there is a rule on medical devices that has increased the safety and efficacy of the product. And so we see that we are walking on two separate tracks which speak the same language. From the viewpoint of the patient, as I said, there is just one flow with the same aim, which is the provision of services and the final result. So I'm asking, I see close interrelationship. Which are the three risks in your world that cannot be postponed because your world is becoming increasingly complicated, surgery is becoming more and more important? What are the risks that eye surgeons, eye doctors nowadays want to limit as much as possible? Well, like all doctors, sorry, we cannot hear you. All right, so there is the risk. The risk that all doctors want to avoid is that of going to court. And Italy is one of the few countries in the world where criminal liability exists for doctors as well. Now we are trying to limit or remove criminal liability completely. During the COVID pandemic, there was a sort of criminal protection for doctors. And by the way, in criminal proceedings, only 3% of cases are then receive a conviction, because in only 3% of the cases the doctor is guilty of medical malpractice. However, patients still tend to file criminal complaints because they are free of charge. You file a complaint at your local court. The local court is obliged to open a file. You don't pay for a lawyer or for a consultant. However, the doctor obviously wants to avoid problems as much as possible, and to do so, measures were taken. Defensive medicine, for example, is one avenue with a lot of useless examinations, which have a double disadvantage. On the one hand, useless healthcare costs for the state and long waiting lists for those who really require those investigations, for example, MRI. And so on the one hand, we have oncologists who perform MRI and who have to do with people undergoing MRI simply simply to be 100% on the safe side. And so this is one of the issues that we have in our healthcare system. And then, on the other hand, we also have the problem that complicated cases are rejected by doctors. In the past, complicated cases were usually operated. The eye is lost, however, let's try and do something through surgery. Now it is no longer the case because when the eye is lost, you run the risk of receiving a legal complaint and a claim for damages, and you may be obliged to pay. So that's the reason why such complicated cases are no longer surgically operated, and this is a disadvantage that we have in surgery in general. President Afragali, does defensive optics exist? So let's make an example. When opticians are confronted with problems, what do they do? Do they also receive complaints? Or the fact of referring a patient to an eye doctor, is it a defensive measure? No, I think it's a moral measure. So let's put claims for damages and accidents aside for a while. Well, it's a very delicate issue for the following reasons. We all know, and we all say and reiterate that we should not perform diagnosis. It's a sort of a mantra nowadays, but at the same time we perfectly know that while performing our activity, we unfortunately, come into contact with situations that may be pathological. Well, you know, but you perfectly know from the very beginning that this is the situation when you perform investigations on the lens, for example. And well, you know, it's a very delicate issue because when you are before the court, well, I provide consultancy services. To colleagues of mine, and I know that this is a problem which is quite frequent. So whenever I identify something that is potentially pathological, how should I behave? Well, the worst behavior is to ignore that. Well, it will be okay because I'm not obliged to identify a disease. But this is defensive, the defensive optician's approach. Well, from an ethical perspective, I think the right behavior should be the following. Well, I think you should inform the patient about the problem as an optician. You interrupt your service, or if you cannot, you should inform the person in front of you that the activity, the service that I'm providing is not able to solve his or her problems completely. Well, we may solve part of their problems, but other problems, which are much worse, have to be addressed by another person. And this is an approach that is going to be managed in a virtuous way. So we have been insisting, and this is not my personal interest, because I repeat, from a mere economic perspective, I don't earn anything out of it. Because when I interrupt an activity and when I tell the patient to go to the eye doctor, well, I lost a sale, I know. I missed a sale, I know. This may not be politically correct, but that's the reality. And this is a situation that, in my opinion, can lead to very important virtuous behaviors, because as we said multiple times, we are literally on the street in the front office. So we are on the field, and opticians are those who can often intercept and identify specific pathological situations, diseases. So it would be appropriate to develop an operational protocol in order to manage those situations in the best ethical way. So if I am confronted with these situations, how should I behave? What measures should I take? And this is a protocol that, in my opinion, should be published. A question to the lawyer. Let me share a story. An optical store underwent an investigation by the healthcare police, and so well, a customer said I had glaucoma because of this store, and the word glaucoma was written on a sheet of paper, and that's what was challenged by the police. What should be the right behavior, and what should be the consensus to develop this type of procedure? I always try not to focus on an individual case. Well, you know, I'm a journalist. Yes, you know, because individual cases may have their own peculiarities. So, well, clearly the police are particularly aggressive. Well, there are the Italian healthcare police or not? Yeah. But they tend to exaggerate, and then, within the framework of a legal proceedings, this case may be made less worse. I'm very pragmatic from this viewpoint, so I think this is a risk that we have to take into account. Because of our job profile, I think no one of us can feel 100% safe. There are always risks, and then of course there may be some additional damages due to media visibility and so on and so forth.
Beh, insomma, dipende come attacco il giornale, dipende anche.
Well, I forgot the question in the meantime. Yes, the story of the glaucoma and the Italian healthcare police. Well, opticians have internal rules of behavior, and so should they defend themselves before the court, they should point out that this is the modus operandi of the store, and so this is what the customer reported. Fragoli mentioned the possibility of defining a protocol as a bridge. Well, I think this may become reality because, as I said earlier, our sector is a special sector. It is a healthcare sector, but a very special one because other healthcare sectors usually work in public or private sectors where services are provided in the same location. And so the usability or the definition of protocols, building bridges among the different disciplines is unfeasible for us. Well, if you think about the investments that were done to enhance the provision of healthcare services at a local level, well, we must define protocols in order to define who does what in the different disciplines. And if no training is provided, healthcare cannot work. A possible protocol in this sector is therefore very important for organizational and collaborative reasons, because at the end of the day, this can increase the clinical efficiency. Protocols are much stronger, much more powerful than a piece of paper, right? Well, my job is that of a lawyer, and I know, paperwork is very important, and in other sectors, however, paperwork is just considered as a nuisance, as a waste of time. However, when legal complaints or when controversies arise, you do not necessarily have to go to court. There is also mediation as a possible avenue. But, it's not a matter of winning or losing. Those who win have the evidence. Those who win are those who are able to provide through evidence of their right behavior. And written evidence has a completely different weight than oral evidence. I know, but every time something is written down, it becomes much more effective. Our law firm is ISO certified, and when we started writing, we realized a lot of things. We identified a lot of things that were not mistakes, but that did not work properly. Let me try and translate these words into the daily practice. Well, let's do as if a customer of mine, whom I've been assisting for many years, with a specific path, with a lot of devices, investigations, and so on and so forth. Well, this customer comes to me one day and he says, well, I cannot see very well with my current spectacles. Okay, let's investigate that. So I use many different devices, the autorefractometer, for example, and I find out that there is opacity of the lens. So as I'm in my practice and as I'm used at working in a certain way, I just write cataract down and I refer the patient to the eye doctor. And that's right, there's a cataract and you refer the patient to the eye doctor. So you did the right thing. However, if you are unlucky and the week afterwards the police come to your office, they seize well, the last 10 clinical files, and they find out that you wrote a cataract referral to the eye doctor. Well, that's a problem for you because you basically performed a diagnosis and opticians cannot develop any diagnosis. Well, that's a stupid thing, but instead of writing cataract referral to the eye doctor, if you write referral to the eye doctor because of suspect disease XY, well, you did the right thing because you did not perform any diagnosis, and what you wrote down cannot be challenged. Well, you know, that's peanuts unless the police finds it out. Well, what I have seen in the past 7-8 years when I provided consultancy services to colleagues and I liaised with lawyers as well, well, I see that there is often an attitude or a behavior that is not particularly attentive. So colleagues of mine who are not very precise in doing things. So they certainly worked in goodwill, and however, they caused damages to themselves because of a wrong behavior. And this can be solved very easily. So the protocol can be very useful in this respect.
Would you like to add something, Professor? Well, for us, the problem is a daily problem. Since 1982, I've been dealing with this issue. And the involvement of a neurologist in that trial was a complete, utter lack of justice. But in the clinic, where we have specialization school, where we have residents, we are confronted with this problem on a daily basis. What is written makes history. When you go to court, you don't have the operating theater, a video of the day. It's what you have written, and what is not written has not been done, and what is poorly written, it's your trouble. So there's aggressiveness in the medical world, but if somebody stumbles in the sidewalk, they go to court. We are in this phase with so many lawsuits. Nowadays, you have informed consent, which is longer and longer. You should inform and state everything, specify everything. And this is happening in your world. And I do realize the importance of words, commas, sentences. Little is necessary to end up in trouble. That's what I'm witnessing. And definition of roles. By defining roles, I believe that everybody will be reassured, because if the world of opticians has rules, well-defined rules, because clear language, the world of daily life clashes with the juridical world. You think you've done something well, but when you go to court, what you thought had been done well caused you trouble, because their mindset is different. If I write a record poorly, well, if it is written poorly, it's an act of responsibility not to have placed the stamp, the signature, not to have written it properly. And so I see that such things are happening also in the world of opticians. Yes, it's interesting, this exchange. Last phase of the debate, convergence. Can we show such last few slides? Yes. So we try and understand the first potential process of convergence, the problems encountered by the optical center, and how the eye medicine world can respond. 1 year ago, some colleagues stopped me and they told me, if we have an urgent problem, how can we solve the problem? And so that's why we decided to start the CISO emergency unit. Over the past few years, you have a considerable increase in patients with infections, inflammation, allergies, and you have a problem of waiting lists, and emergency rooms are crowded. If this patient goes to emergency room, who knows when he is visited? And CISO promotes the setting up of a network of eye doctors on a voluntary basis to offer timely, qualified answer to the eye urgencies of citizens. And how does it work? The citizen is addressed to the service through pharmacies. Pharmacies are becoming pharmacies of services. Pharmacies are front office. Very often, patients also go to an optical shop, and they go to pharmacists, general practitioners, and we give them CISO information material, and then the eye doctor will tackle the problem quickly. So we started, we haven't started, we haven't yet sent it, but we'll send it. Well, the result will be like, I will tell you next year. But as I'm stubborn for the moment, we sent all CISO members. Last year we exceeded 2,700, 2,400, and this year in January the figure is even higher. We want to get to 3,000 by the end of the year. And for the moment,
ovviamente gli diremo con una tariffa che è quella.
Obviously, there will be a fee, and the optician calls the pharmacy, and in the course of 24 hours, the patient must be seen if you are available. And if we don't have the feedback that we expect, it's 40 professors in Italy will start calling colleagues, because nobody became an eye doctor through self-imparted procedure. They attended a specific school. And so I call a colleague and I asked him if he has 5 doctors available. So on a voluntary basis, we see how many respond and if they respond. If they do not respond, we'll try and push more. Because it's right, such people will have a return from this activity, but it also has this social effect. The optician association places this right request, and this proves there's a meeting point between the two professions. And President Afragoli, I pay tribute to him, and no screening, no diagnostics, no diagnosis, he says, because I decided to follow a different procedure. If I had wanted to become an eye doctor, I would have graduated in medicine. So we now must give an answer to opticians. A round of applause.
È vero che il Mido è
It's true that Mido is about glamour and wonderful eyewear, but what you said is quite important. So, what's your comment? My comment is more than positive, and you don't have words. Okay. We'll see in the course of the year how we can make it all operational. When, sorry, comments out of the mic. So you can communicate it to your network, and then the optician will choose the nearest professional. I'm convinced that this will bring about positive elements that will be recognized by each and everyone. First of all, our users, by us, and by ophthalmologists. I'm convinced that it will be a virtuous process, and as a consequence, it will allow us, I'm convinced about it, what we said before, a procedure that allows us together the way we can approach our users to explain with the right words the problems we are encountered with. I believe it's a small spark, no, not small, but spark, no. I shouldn't use this term considering what happened recently. A small water drop, and everything has started here today. So we'll also need a good lawyer, and lawyers are always ready. Just a final remark, and also in defensive terms, if everything is in a well-defined process, everything is of great help. Thanks a lot to our 3 speakers.